Okay. Now you're on.
All right. So we'll start off with Josh. We got two concurs, not concurs. We'll start off with the Juvenile Restoration Act.
As passed by the Senate, Senate Bill 494 authorizes a court, when sentencing a minor convicted as an adult, to impose a sentence less than the minimum term required by law, and also prohibits a court from imposing a sentence of life without the possibility of parole on a minor convicted as an adult. The bill also authorizes an individual who was convicted as an adult for an offense committed when the individual was a minor to file a motion with the court to reduce the duration of the sentence and establishes related procedures. Finally, the bill provided that as a condition of granting a motion, a court may require participation in certain programs. The House amendments made some technical changes and additionally struck the provision authorizing a court to require participation in certain programs as a condition of granting a motion.
They struck out the amendment that was added on the floor. They would allow the judge to add certain preconditions for the hearing or for the actual release. For granting the motion.
That would mean that the judge would have to bring them over. Yeah, and we added that because, I mean, it made sense because the way the statute's written, you would have to, the judge would have to bring somebody over and then say, if the court wants to say, hey kid, I'd be interested in granting your relief, but not just yet because you never did the educational program or whatever, they would bring them over and then they'd have to just deny it. They'd say, well, I see you're here for this, but I don't let kids out who don't have their GED. So, denied. That's their only recourse. Otherwise, they could say, okay, your motion is pending, but before I bring you over, I want to see a GED. I mean, it seems to me that this is counterproductive because we want the courts releasing kids, but you're going to have judges who just are going to say, I'm not going to reduce this because you've not done anything on education, and I'd be willing to do this. So I'm going to hold it. I'm going to hold it, and I think that this strengthens the bill for the advocates who want juveniles to be restored, to be released. So I think that's unfortunate that they're taking that position.
I'd like to move to concur with the House.
I mean, I'd like to have maybe somebody could offer some logic, because I'm so damn tired in this of having votes just because the House, we lay out things in logic and then we say, yeah, but we don't do logic anymore. This is the General Assembly of Maryland, so let's just do this anyway. Maybe somebody just to humor us could just offer some logic. It would just, I don't know, it would be somewhat amusing to hear, perhaps.
The arguments that I've heard is that sometimes for if you're saying, hey, you need alcohol treatment or you need some sort of assessment there, is that sometimes those resources are not, depending on which facility you are in, you don't have access to some of those resources for whatever preconditioned treatment you need or something like that. That's the argument that I've heard, and that's what I heard from the House, just that the resources may not be there. And also, this is absent the actual process that you'd have to go through to get to this point of petitioning in the first place. It's a first look. You're not going to get it. And then they're going to say, look, we'll evaluate what you've done, but you're going to go back and we're going to set some benchmarks. I mean, no one gets released after that first hearing anyway. And so I think that's actually why that's an important look, because you're going to get that first look and you're going to establish some benchmarks and some goals to move forward. So, yeah. Go ahead, Senator Carter. More rationale and discussion. Senator West.
Could someone read the exact language that we added on the floor? Frankly, I don't remember the amendment. Was it a friendly amendment?
Do you remember I took it as it wasn't an unfriendly amendment, But I've since, again, in looking with the discussions at the House, and I spoke to a couple of the folks that practice in this area, and they just said that it didn't make as much sense as it kind of came off initially, just because, again, some of the preconditions are not available in certain facilities. So, I mean,
So does someone have the exact language of the amendment that we adopted?
Yeah, so it's a new subsection F at the end of the bill, and it states, as a precondition to granting a motion to reduce the duration of a sentence under this section, a court may require that an individual complete any of the following: pre-release programming, alcohol and substance abuse treatment, a GED program or other educational or job skills training program, or a reentry program.
So would it help to just amend that language a bit to say the judge may adopt any of the following which are available to an inmate at the particular correctional facility to which this inmate is confined, and then have the list? Would that solve the concern expressed in the House?
I think there's a procedural issue here that it's either, this is kind of a concur, not concur, no amendments.
Right, no,
That would have to go to conference committee.
Okay, so we can't concur with amendment,
No,
which would send it back to them for their final, we can't do that.
no.
Take it or leave it.
Take it or leave it.
Well,
Take it, leave it, or conference.
If you don't, you either take it, proceed, take theirs, or you not concur and you go to conference. That's
Correct.
your choice.
That's right.
Why don't we not concur and go to conference, and we can add that language? Seems to me that language solves their problem, and I wouldn't mind having that language. It would be inappropriate for a judge to require some kind of a pre-release program which the inmate can't take because it's not available to him. That's stupid.
Castley and then Vice Chair Walsh-Reiger.
Yeah, I'm just curious. I hear you're saying, well, we've talked to people who practice in this area, and here's how this is done. That's interesting because this area doesn't even exist right now. This has never happened before. This is brand new law. So to say, oh no, this is how this works, they're as able to say that as any of us to say that. A judge isn't going to say, oh well, you've got to do this. Well, you can't do that. So that's sort of, it's like a cruel April Fool's joke. In order to do this, you have to take tap and ballet. It's not offered, so I'll never let you out. I mean, that's not gonna happen. So, to suggest, the judge is going to issue these conditions, knowing that, judges know what the heck is available to these people, and the judge isn't going to say, oh no, you have to do this, and it's not offered there, and so this is sort of a ruse for me to pretend that I'll keep you in there till hell freezes over because you can't possibly satisfy the precondition. So I don't see you. And what we're saying is, well, you'll come over, I guess, and at then that point, the judge will say, well, I would have granted this, but so you're going to go back. This area of the law is really fun. Thanks.
And some of the folks that actually represent some of these juvenile lifers practice in the area. Obviously, I know we're building new law, but it's funny. But the people that represent juvenile lifers. So it's funny. The word they use is that judges don't know what's available in certain facilities. It's really is what literally the sentence that this woman said to me. So go ahead, Vice Chair Walsh-Reiger.
I'm just trying to play this out. If they're represented by the people to whom you spoke, wouldn't the person speak up and say, like if the judge says, hey, you're doing great, but I really want you to attend more alcohol treatment, but there's no alcohol treatment in that facility, wouldn't the attorney speak up and say, hey, judge, appreciate what you're saying, but there's no alcohol treatment at our facility? And to the extent that the language is a may, I don't understand. I'm just struggling with how it's objectionable to have where the judge has a may, not a shall, and where the person is represented by counsel who can express what the conditions in the facility are. I'm confused why it's objectionable.
Just going to say, the bill is Senator West's bill. If he doesn't want to concur, I don't know why we would concur over what the sponsor wants. If he wants to go to conference and work it out, we can. I don't know if people are worried about deadlines or whatever, but they can conference it even on Monday if they want and work it out. Quite frankly, we just spent 2 days rewriting a whole bill and passing it, a giant bill. It's like one line they're talking about, a deference for the sponsor. I think we should, if he wants to conference it, just conference it. I think we receded enough.
I'm getting word that the advocates don't want a conference. They just want to concur. I don't know why in the world a conference, if it seems to me my idea of adding that extra language is so obvious and so clearly the way that this would totally be solved to everyone's satisfaction. I don't understand why we can't have a virtual conference which would last 10 minutes, adopt this additional language, and then have done with it.
So.
I just make an observation that there's not quite 7 million citizens in Maryland, and we sit around taking, who probably this room represents a majority of those, almost nearly 7 million people, and as we sit and think about legislation and deliberate on it, I just find it odd that we take direction from one citizen who's probably not even in your voting district on how we should deliberate and think about bills. It's just, I find that bizarre. I call it the Twitterocracy.
Well, in response to that, it's not unusual for advocates to be emailing us during the course of our deliberations. This is not the first time this happened. And number two, I disagreed with the advice I was getting. So I don't feel like they're pushing us around.
We have an awful lot of work to do in terms of landlord-tenant issues, so I'd like to press my motion and move to concur, which was seconded by Senator Carter. Roll call.
Bill, I mean, with all due respect, I know you want to get things through, but you have the sponsor sitting right here in the committee. Why don't we just let him, if he wants to conference for 10 minutes, just let him, out of due respect. I mean,
Senator Carter, real quick, and then.
I'm going to be really quick. I mean, to be quite honest with you, this is how the bill passed out of the committee. We did take a floor amendment. But the bottom line is that this isn't about, overly prescribing what should happen before a judge can make a decision in these cases. And so this is about our belief that these people that are sentenced as children are entitled to some type of review, and leaving it up to the court to make an informed decision about whether or not they should have release or whether or not their sentence should be changed. So I don't understand why anyone thinks that we need to overly prescribe what preconditions might be there before a judge can make that decision. So because I'm a big believer, and you all know this, in judicial discretion, I just don't think it's necessary. So that's why I'm seconding the amendment, and hoping we can just concur. I mean, seconding the motion, I mean.
I hear your argument, Senator Carter, and everything you just argued supports leaving the amendment in. This amendment provides judicial discretion. It's a may. It gives the courts more flexibility in how they deal with this, not less. The court doesn't have to do anything. A court can say, well, I may do that, but I don't have to. And when I may do it, I can do these other things. There's no requirement. This does not restrict the court in any way. This supports your whole concept of judicial discretion. So you're saying that under the bill as it's written, that the court gets a motion to comply with this, the court gets such a motion, and then the court somehow manufactures an authority to say, oh, well, I'm not going to hear this until you meet the following conditions. Even though that's not in the statute, the court's going to add in conditions before the relief is granted and say, I refuse to hear your petition until X is done.
Because I don't think it was about that. I thought it was about the judge making the decision on the petition, not hearing the petition.
Yeah, it's about when the judge gets the petition, then the judge has the discretion to say, before I bring you over and hear this, I've reviewed your file, and I'm directing that you undertake the following things before you come over here. Before we have a hearing on this, because as I read the statute or the bill, we have a hearing, and then the judge has to rule on it, and the judge at that point, and under all the time constraints, I think you end up selling the kid short. So I'm at a loss to understand the hesitancy to grant judges greater discretion and lesser discretion based upon your argument.
Thank you, Mr. Chair. I think Senator Carter's brought up a good point. So I need to turn to counsel here. So when counsel receives a petition from an inmate under this bill for early release, does the judge have the powers, irrespective of the amendment that was offered, to say, I'm going to grant you release conditioned on your completing an extra 100 hours of whatever? Is that part of the powers of the judge, or do we need this amendment in order to accord to the judge the power to impose that condition on the release? Can counsel answer that?
The timelines in the bill are not specified. It simply states that when a motion is filed, a court shall hold a hearing, and then after that, they may grant the motion. There may be some allowance in that for a court to hear the motion and then delay a final ruling on it for some period of time, and and maybe say, if you do a program, then maybe I'll grant. But the bill is silent as to when a hearing or a ruling has to be made. So
with respect, that wasn't my question. My question is, does a judge of one of the circuit courts in Maryland have the power, just in general, to grant this kind of a release, but condition it on something like completing an extra 100 hours of such and such? Or is the judge not empowered to impose such a condition? And therefore, this amendment is essential in order to empower the judge to grant it. In other words, does the judge have the power right now to impose the condition, meaning this amendment was redundant, or is this amendment essential in order to give the power to the judge to impose such a condition?
I would have to look into it further to be exactly sure, but I don't believe so, because, when the motion is granted, the motion is granted. I don't think they could say, they could condition a grant of a motion on something unless that were specifically authorized.
Because I believe that in criminal cases, judges frequently place conditions on.
Thank you. Well, Senator West has a point, and I think that now, once again, typical JPR, we're making something more complicated maybe than it needs to be. The language of the bill, to my understanding, says the judge, the motion to hear it shall be granted, right? Hearing it. But absolutely, in any situation, in any type of sentencing or resentencing or modification of sentence or post-conviction or any other time that a court reviews a sentence, they absolutely have the authority and the discretion to decide, okay, I'm not quite ready yet. I'd like to see you do this, or I'd like this presented. Let me hold it sub curia. Let's delay disposition for 90 days and let me see if you can accomplish this. They have all of that discretion in these kinds of situations. So I think it is there's no discretion on granting the hearing under the bill, but making a final disposition upon the hearing and review of all the information, they absolutely can do that. Because they always can. I mean, I don't think my opinion is it's redundant.
having learned that, and I don't hear anybody disagreeing with that, I think that the amendment indeed was redundant, and we should go ahead and concur in the House amendments.
Just to push back a bit here, that so unlike other statutes, I mean this the rights the judge has are pursuant to statute to impact the sentence. This statute isn't the other statutes that that Senator Carter is referring to. This statute is a new statute, and it says notwithstanding any other provision of law, after hearing under subsection B of this section, the court may reduce the duration of the sentence imposed on an individual for an offense committed when the individual was a minor if the court determines that the individual is not a danger to the public and the interest of justice will be better served by reducing the sentence. It doesn't say, there's nothing here that says that the kid will be better off, that the kid's going to have a better, like he's going to come out educated, or anything like that. This is really specific. All he can do is say he's not a danger and this is justice. But justice doesn't mean that Johnny won't go back in the streets and be uneducated and addicted and everything else. All justice says is that he's not going to go kill more people or something like that. So I just disagree with with Senator Carter's interpretation of the law, because the other laws are very specific on how we deal with sentencing and reductions of sentence, and this is a whole new law.
With all due respect, Senator, I can't imagine that the law of Maryland would decline to accord to a judge in such a situation the opportunity to hold the case sub curia for a period of time, and then consider the case at the end of that period of time, in light of the fact that the inmate has done certain things that the judge suggested to the inmate that would have to be done for the judge to approve the motion, the petition. Do you really think the judge doesn't have the power to hold the case sub curia under this bill? That power is taken away from the judge?
Passed, obviously, and then you'll sit and you'll wait and we'll find. They can't manufacture their power. I don't know if they have, quite frankly, none of us really know what the courts will do here. The intent of the amendment was just simply to clarify that and make it clear that their only choice was not simply to say you're not a danger. I mean, the way this is written, it's just the only choice the judge has. If the court determines that the individual is not a danger, that's a big, say, well, you're not a danger to society. That's very, very different than saying, and you've accorded yourself right, and you'll go out of here and you'll be a productive member of society. Very different things. This doesn't give him, in my view, the discretion to say, and I could see defense counsel getting up and saying, Judge, quite frankly, that's none of your business. The court's found that Johnny Jones is not a danger, and so you need to just grant this and move on. So,
Mr. Chair, can we move the previous question? This has been debated long enough. The motion's been seconded. The motion's there.
I want to make sure we had time for debate, so everyone has an opportunity,
Vice Chair Waldstreicher.
The motion is to not concur?
No, the motion is to concur.
The motion is to concur, yes.
Senator Lee.
Yes.
Senator Castley.
no.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
I'll go with the Senator West. Yes.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
Yes.
Motion to concur carries.
Motion carries. What's the next one? What's the number for the next one?
Senate Bill 202.
Senate Bill 202. Josh.
As passed by the Senate, Senate Bill 202 increases the amount of time that an inmate who has been sentenced to life imprisonment for a crime committed on or after October 1, 2021, must serve before becoming eligible for parole from 15 years or its equivalent considering diminution credits to 20 years without consideration of diminution credits. The bill also provides that an inmate sentenced to life imprisonment may be paroled only with at least 6 affirmative votes of the 10-member parole commission. Finally, the bill eliminates a requirement that the parole of a person sentenced to life imprisonment must be approved by the governor. The House amendments struck the amendments adopted by the Senate and returned the bill to its original form by reinserting allowances for diminution credits and striking the requirement that parole be approved by 6 members of the parole commission.
I mean, I would not concur. That's outrageous. And so, first off, to not have at least 6 people on there, why they struck that, to me, is just, quite frankly, I mean, to get back to the activists, I mean, why would you strike that? That is the most common sense amendment. I have no idea why they would have done that. And then to say to take a first-degree murder or first-degree rape and make them eligible with good time credits, I don't actually even know what that equates to. What is that, 15 and a half years?
That was,
So we're now going to have, we have no idea the number, we went through this whole discussion painstakingly. We have no idea the number of people that are going to actually vote to parole somebody, because we actually took the time. I have no idea what the House did, if they actually looked at what the COMAR and the regs are.
Let's do a motion to go to conference. Let's not concur. Let's go
Yeah,
to
not
conference.
concur.
Okay, all right. Is everyone okay with that? We won't have to do a roll call on that. We'll just do that right now. Or we'll get this thing started right now.
Who do you want to go to conference?
All right, let's appoint the conferees right now. And our Senator Carter will be there. Okay, we need 3, right?
Yes.
All right. Who among them? All right.
Wait, are people actually going to stand up for the Senate position on the conference? I mean, to be honest, let's start with the
Just to have this argument, you heard the argument in here before.
Well,
about the
I hope
composition.
that people who are going to be in the conference are going to stick on the Senate position. If not, I would prefer I mean, do you like the House position, right?
I think the point of conference is to see where we are and try to work out something so we can get a bill passed.
Well, the point of conference, though, is to start off advocating for our position.
Absolutely.
The 2 of you and Sidnor. You want to be on that conference committee? Huh? All right. Just. All right. Or do you want to be on the conference committee?
Looking at me?
Yeah.
I'll do whatever the chair pleases. I am at your disposal.
No, you did. Charles, you not? Between the 2 of you,
Whatever
You're
the
not
chair
anxious
says,
then?
It's your call.
all right. You, Huff, and Walstriker. All right, so that's it. So we've got Senator Carter, Senator Walstriker, Senator Huffer on the conference committee. We are going to adjourn the voting session now, and then we do a work session on right to counsel. So some folks get back for that. But that's it. All right, see you guys on the floor.